Welcome to Direct U.S. Immigration's channel, where you get direct access to our most up-to-date immigration and global mobility space. My name is Maitreya Brown, and I'm going to talk about a non-immigrant work visa that allows U.S. employers to hire foreign workers for specialty jobs that require a bachelor's degree or equivalent. This can include occupations in fields such as IT, healthcare, finance, engineering, and more. You're not going to want to miss this one. Stay tuned. Thanks for tuning in. My name is Maitreya Brown, and I am a U.S. immigration attorney based in Washington, D.C. I'm also the principal attorney at Direct U.S. Immigration, where we work with clients in all 50 states and around the world. Before we start, click on the like and subscribe button to follow our Immigration Hub to get the latest immigration news that may be vital to your case. The U.S. visa that I'm going to talk about today is the H-1B visa. Its requirements can be difficult to meet because you first must be offered employment by a U.S. employer that is willing to sponsor you. Competition for jobs in the United States is fierce, and demand for the visa to enter the U.S. grows daily. Furthermore, there's a limit on the number of these visas granted each year for certain first-time prospective H-1B holders. So in this video, we'll talk about the H-1B visa. Ensuring that you have all of the information up front will avoid costly mistakes in the future. So the H-1B visa is a special visa that allows foreign nationals to enter the United States to perform specialty occupations. A specialty occupation requires, at minimum, a bachelor's degree or enough work experience to equate to that U.S. bachelor's degree. Now, the work can be in many fields to include architecture, engineering, mathematics, science, medicine, health, education, business, law, accounting, technology, the arts, and more. Now, because there is a lot of demand for this visa, there's a cap on the number of visas that can be issued each year. Currently, the cap is at 65,000 visas per fiscal year. Now, if you have a master's degree from a U.S. institution, then you're in luck. An extra 20,000 visas are available for those with a master's degree or higher. So suppose that the employer who wishes to sponsor you is an institution of higher education or a nonprofit organization connected to an institution of higher education, or perhaps even a governmental research organization. In these cases, the cap does not apply to your application. Now, there are many benefits of having an H-1B visa, and here are just a few. First off, you can legally work in the United States. Now, this allows a highly qualified individual to work and live in the U.S. where it benefits both the individual and the U.S. economy. Second is that you can simultaneously pursue permanent resident status or a path to the green card. So the H-1B visa is a dual intent non-immigrant visa, which means that you're not required to have intent to exit the U.S. when holding the visa. Third is that your immediate family can join you. So when I say family, I mean your spouse and your unmarried child or children under the age of 21. So again, like I said, they can join you in the United States in H-4 status, where your children can go to school and your spouse can work so long as you, the H-1B holder, have an approved I-140 and the spouse has applied for a work authorization document, also known as the EAD. Fourth is that H-1Bs have visa portability. So one big advantage of the H-1B visa is the portability benefits. So if you are on an H-1B visa and you change employers, you can begin working with a different employer upon filing the new petition. So the general steps that you must go through in order to apply for an H-1B visa are: first, you must make sure that you qualify for the H-1B visa. Second, you must find a petitioner by applying for a job opening in the United States. Third is that if this is your first time applying for an H-1B visa for a for-profit institution, so a for-profit company rather than, of course, a nonprofit, then you will need to be placed in the H-1B lottery to be selected to apply for the visa. Fourth is that if you have a petition initiated by an employer, so basically that employer is going to sponsor you for that visa. And fifth is if you're outside of the US, then you would apply for that H-1B visa stamp in your home country at the embassy or consulate closest to your home. Now, if you're in the US, you would just change status. Now, there are many conditions that need to be met in order to qualify for an H-1B visa, and an immigration attorney like myself can help you determine whether you meet those provisions. Direct U.S. Immigration can also help you organize evidence to prove eligibility. So please be aware that those working on an H-1B are subject to random site visits to check to ensure that that individual is working at the right location, is under the correct job title, and of course is being paid the required minimum salary that the Department of Labor approves. So like I've said before, you do need to have a job offer from a U.S. company. So the employer must extend a bona fide job offer to the beneficiary. And this can be through a written contract, or even if there's no written contract, through a summary of an oral agreement. Second, there must be a valid employer-employee relationship. So this is very important because it's a mandatory condition. So for a valid employer-employee relationship, there must be employer control. Now, control is the ability of the petitioner, so the employer, to determine when, where, and how the beneficiary or the worker completes his or her duties. Now, USCIS will deny a petition if the beneficiary is not an employee and does not report to the petitioner. Also, there must not be any labor disputes or strikes at the workplace and the H-1B classification sought for. So USCIS will deny petitions if there is a strike or other labor dispute at the prospective beneficiary's worksite and H-1B classification sought for the new employee. So basically, the government is trying to avoid employees who are on strike and not working to have their job replaced by a new H-1B worker coming in. Also, the job must be considered a specialty occupation position. So a specialty occupation requires the theoretical and practical knowledge of a field. So to learn whether your job qualifies for, that designation as a specialty occupation, you can reference a couple different government sites. So the Department of Labor's Occupational Outlook Handbook, the Department of Labor's ONET online system, and or the Department of Labor's Dictionary of Occupational Titles. Also, the job must require a bachelor's degree or higher or its equivalent. So, like I said, it has to be a U.S. bachelor's degree or higher, specific to the field of study related to the occupation or its equivalent. So not all foreign degrees titled bachelor's degrees are equivalent to a U.S. institution's bachelor's degrees. So for example, in some countries like India or Brazil, some institutions issue a bachelor's degree for 3 years of study versus the traditional 4 years of study that is required in the U.S. So therefore, USCIS typically requires an educational credential evaluation of that foreign degree and transcript. And this will also help prove that you do in fact meet the U.S. Bachelor's degree requirement. Now, the American Association of Collegiate Registrars and Admissions Officers Electronic Database for Global Education, I know it's very long, but we generally just call them EDGE, is the most popular credential evaluator. Now, exceptions do apply, so if you do not have the academic requirement standard for the job, then you can still qualify for an H-1B visa. So this can be done through education, training, and work experience. So here, a petitioner must demonstrate that the previous experience is equivalent to the required degree. So it can be a mix of things. So it can be a partial degree plus work experience that can in turn be equivalent to a U.S. bachelor's degree. It really just depends on the unique case as well as the individual. Now, of course, to apply for the H-1B visa, the employer does have to pay all of the relevant fees associated with that case. And then kind of back to your credentials, if the federal, state, or local law require that you have licensure, then you will have to have a license. So, and there are actually two exceptions to this rule. So if the state does not require a permanent license, or if the state allows a unlicensed person to practice under the supervision of a licensed supervisor, then you can get out of that requirement. Now, those in the healthcare professions should be aware that state guidelines supersede the OOH requirements. So those primarily involved in research or teaching, so of course not patient care, don't need a license. And additionally, there are some other exceptions that may exist for certain applicants in healthcare professions, but generally speaking, it's on a case-by-case basis and based on the job. Now, like I spoke about earlier, there is an H-1B visa numerical limitation. So every year, 65,000 H-1Bs are made available, with an additional 20,000 visas reserved for those with advanced degrees. Now, any petition not registered or chosen in the lottery after the final receipt date will be rejected. Further, any petition missing mandatory documents or fees will also be rejected. So it's critical to be on top of your H-1B visa application process, and an immigration attorney can help ensure that you maximize the likelihood of success. Now, due to the lottery, many qualified applicants may never be reviewed, and certain prospective reforms have been pushed to change this process. Now, some advocates believe that H-1Bs should be reserved for the highest paid or the most skilled beneficiaries. Yet, this has not been implemented, and the lottery system remains in place as the current process. So currently we have a special lottery system for advanced degree holders, which is held before the regular lottery. So if a beneficiary or a prospective worker with an advanced degree is not chosen in that first lottery, which is that first 20,000 designated spots, then a second chance will be given to, in the general lottery. So in that designation of 65,000 visas. So it is important to note that for advanced degree holders, not only does the applicant need to have a U.S. advanced degree, but the job position must require that advanced degree as a minimum academic threshold in order to take that position. Now, who files the petition? So the U.S. company must file the petition on behalf of the foreign national who will receive the H-1B visa. So the U.S. company is called the petitioner, and the foreign national is called the beneficiary. So like I previously said, the petitioner, so the employer, must have extended a job offer to the beneficiary or the worker. There must be a valid employer-employee relationship. And then, of course, with the business, you do have to have an IRS tax identification number. So petitioners can only file one petition per beneficiary in any given calendar year or fiscal year for that lottery system. And if a petitioner submits more than one application, then the petition or visa will be denied or revoked. However, multiple different companies can submit a petition for the same beneficiary. So here an entity must have its own federal employer identification number, so its own FEIN. And additionally, they must have their own legitimate need to hire that beneficiary, so to hire that worker. So the H-1B visa process is a multi-step process, and there are certain guidelines that you do need to take into account, which of course, if it is your first H-1B visa that you're applying for a for-profit company, or technically if you've held H-1B status before for the 6 years, don't have an approved I-140, exited the U.S. and then are coming back in, then you would also need to apply for that registration period, but that's a whole nother video that we can, discuss that in. But say, the first scenario is the accurate one. So you apply for the H-1B registration period. If you're selected for the lottery, then the H-1B application is submitted. Then the case is adjudicated, it's approved. If you are abroad, you will obtain an H-1B visa stamp at an embassy or a consulate, and then you can begin working in the U.S. Now, if you're already in the U.S., it's probably just going to be a change of status application where you automatically switch to that new H-1B status. Now, in terms of the general list of documents that you'll need, again, This is more of a general list. It's not a comprehensive list because the document types really do vary on the company, the employee, and the job. But basically, you need basic company information, you need a detailed job description, a certified Department of Labor LCA, the diploma and transcripts, certifications, and of course, if it's a foreign degree, an educational evaluation, evidence of licensure, support letters from previous employers if you're using work experience, and of course, a biographic page of the passport of the applicant, so of the foreign worker. So in terms of visa processing time, the amount of time it takes for the H-1B filing and the receipt notice and receipt of the approval really depends on a wide range of factors. And these factors include whether premium processing is available for that application and whether it was actually elected, which type of H-1B visa that you're requesting, so whether it's cap exempt, an advanced degree, or regular, which USCIS Service Center is processing the case, and which U.S. embassy or consulate your passport is being stamped at if you're outside of the U.S. Thus, the process can take anywhere from 15 days to over 6 months, and additionally, regardless of the approval date, beneficiaries that are eligible to work because they did receive the approval cannot work until October 1st of the lottery year of that fiscal year. Now, while on the H-1B visa, there is a path to the green card. So you can apply for both the H-1B visa and the green card simultaneously, and it will not cause an issue for you. So if you are awaiting an immigrant visa priority date, then you may be eligible to remain in the United States for longer than that 6-year initial period of stay, so long as you have an approved I-140. So if you have any questions about going from an H-1B visa to a permanent resident status in the United States, an immigration lawyer such as myself or another member of my team can provide further information. Now, let's talk about some visa exceptions to the H-1B. So, citizens of Chile and Singapore are eligible for H-1B1 status. So, H-1B1 visas are generally valid for up to 18 months and can be renewed indefinitely. Now, you can either apply at USCIS or at a U.S. consulate or embassy abroad. Now, those under the H-1B1 status are not counted towards that $65,000 visa cap, plus the additional $20,000, and are also not subject to that same 6-year maximum stay for those that are on the H-1B visa. So to conclude, the H-1B visa is one of the most popular avenues for foreign nationals to perform specialty occupations in the United States. So you should have a much stronger understanding of the aspects of the H-1B visa, including the H-1B visa benefits, requirements, and the visa application process. So if you have any questions regarding information discussed in this video or about the H-1B visa generally, please feel free to email us directly at inquiry@directusimmigration.com or schedule a consultation with us. I hope you found this video helpful. Subscribe if this content helps you in any way. Comment below if you want me to talk about anything in specific that you might have questions about, and share this resource because you never know who needs answers to these questions. I'll see you in the next video.